So Professor Marianne Franks is the Eugene L. and Barbara A. Bernard Professor in Intellectual Property, Technology, and Civil Rights Law at George Washington Law School. Her areas of expertise include First Amendment law, Second Amendment law, law and technology, criminal law, and family law, but I didn't need to tell you that because I think we all know her work on free speech and about her wonderful new book, which she's going to share with us today. I would encourage you to read her full profile. Thank you for doing this, Professor Franks.
Thank you so much for that introduction, and thank you for being here. I know that it is a very strange time for everyone, but probably in some ways more so for law school students than others. So I do really appreciate the idea that people will still come together and listen to talks about topics that hopefully will still matter, right? That the law will still matter at the end of all of this. I like to think in some ways that this book, and this is what the book looks like, Fearless Speech, Breaking Free from the First Amendment. I sometimes introduce myself with this book. It's been out since October. I talk about how I'm glad that it's got relevant topics in it, but as the days have ticked on, I've actually been sort of apologizing for the fact that it has such relevance because it's not a happy story in a lot of ways. In some ways, and maybe I'll stand up for this to feel like I have more gravitas when I stand up. For what I'm trying to do in this book and what I was working on for the years that I was putting it together, obviously, when I submitted the manuscript, we were not under a new administration, but there was a threat of a new administration. We had seen what the first Trump administration had done. And it's not that the book is about that as such. What the book is really about is, why is it that if we have told ourselves, and we have, and when I say we, many people who have either been in America all their lives or spent substantial portions of their time in the United States, why is it that we tell ourselves that we have this unique perspective on freedom of speech, that we are at the top of the game, that we are the leaders in the whole world because of our First Amendment, that we do it better than anyone else? Why do we have this reputation, this mythology that says we in our country have protected freedom of speech above all else, that we have fought for those who have been radical and revolutionary and have fought for progress, and also included some unpleasant people, but that we fought for progress and that we're very open? How have we got to a point where we are now looking at an administration that openly says that they are, a president who is saying, I want to punish all of my enemies. I want to silence everybody who criticizes me. I want to control the media. I want to control social media. I want only loyalists to me to be able to speak at all. And can not only say that, but say that and say, and I'm doing all this because I love the First Amendment, right? This is not someone who's announcing this and saying, all of these conventions be damned, I'm going to turn everything upside down, but rather, no, I'm reverting us back to our true and glorious history, which is also a history of the First Amendment and free speech. How can that be the case? And if we look around even before the events, the protests that happened on campuses that kind of maybe put this into sharper focus than it had been before, we already saw that when people were trying to protest, for instance, against police brutality, when we were trying to protest against injustices, how oftentimes the government would crack down, right? And often we would see that students would be on the receiving end of discipline or even in some cases harassment and abuse because the things that they were saying were unpopular, even though that's part of our tradition, right? We talk about how it's the 1970s and the hippies and this free speech movement, all of those things are what we care about. And we look, I still think there's still a consensus that looks back on those moments where students were shot at Kent State or civil rights protesters were beaten up. And we think of that with shame, right? And think we're so much better now. And my concern is that, we have all of that mythology, and yet we have the reality that we do, where if you are speaking out against certain types of injustices, if you are making your points known in ways that are disruptive, you are still being silenced, you are still being repressed. And so maybe it's an obvious point to a lot of you in this room, but it's not an obvious point, I think, to a lot of people who count themselves as civil libertarians to say, we have a free speech tradition in this country, but it is an extremely selective one. There are certain kinds of speech that have always been given forms of protection. There are certain speakers who have always been could be fairly well assured that they were going to have the freedom to speak. And then there's been everybody else. And the way that I would describe that everybody else and how that selection has happened is that it's not arbitrary. It's not just really, well, who knows on any given day who's going to win or who's going to lose. It's very, very specific. what it is that the speakers that have been most closely associated with the original vision of the United States, the founding fathers, as we often refer to them, they have experienced maximum protection for their speech. And if their ideas are the ones that converge with that very neatly, right? The idea that there's power in your race, there's power in your gender, there's power in your wealth, that has all been really well protected. All the moments, though, in history, all the speakers throughout history who've actually pushed back to say, actually, we the people didn't mean we the people, here are all the people who were excluded, and we need to start making clear that we the people was a lie, and we can make it into the truth, and we should make it into the truth, but it is a lie, and we need to advocate to get that aspiration into reality. Those people, right? Every movement we can think of, the abolitionists who were fighting against slavery, the suffragists who were saying that women deserve the right to vote, right? The labor movements, civil rights movements, over and over again throughout history, those particular movements have been largely suppressed. There have been exceptions. I don't want to overstate the history here, but they have largely been suppressed. They have been met with tremendous resistance by citizens, people, non-governmental actors, and they have been not particularly protected by the First Amendment. In the book, I try to lay out that history because I think it's important for us both to disabuse ourselves of the mythology of the First Amendment. And when I talk about or try to explain why it is that the subtitle is Breaking Free from the First Amendment, it isn't to say First Amendment is bad or First Amendment is really good. It's basically to say it isn't enough. It is not only not enough sometimes, that is to say it's not sufficient for the protection of freedom of speech, especially freedom of speech that is pro-democratic as opposed to anti-democratic. It's not sufficient for that, but it's also, and this is where people leave me a little bit, it's also not necessary. It's not necessary, and we know this because we're the only country that has this thing called the First Amendment, and it's pretty unique in many respects, but it doesn't mean that we're at the top of the free speech game. You look at statistics that show that in-depth indices of press freedom, for instance, in the United States, ranks us about 45, 46 out of about 160 countries. When it comes to global freedom of expression rankings, we're about 20-something, right? So we have this thing called the First Amendment that we think is the most radical, maybe, and most capacious view of freedom of speech, but it turns out we don't really do necessarily that good of a job. And for any of you who have studied the history of the First Amendment, you also know that for a really long time, right up until, officially we can say 1925, it wasn't even the court's view that the First Amendment applied to anything other than Congress, that it really meant what it said, which meant really, really narrow scope, which means that when we're talking about all those great movements in the 1800s, none of them were being protected by the First Amendment. It wasn't even thought of as something that could protect them. And then when you got this incorporation idea that the states do have these First Amendment obligations, you got very selective protections. And what you largely saw is that the people who were at the edge, who were saying, we are going to protest against the status quo in terms of its racism, in terms of its sexism, in terms of its warmongering, those people in all those early cases lost and lost and lost. So we're talking about a very long period of our history, basically from the very beginning, that says we are not protecting freedom of speech, at least not through the First Amendment. Now, what does that mean? Does it mean if the First Amendment is neither necessary nor sufficient for protection of freedom of speech, then is the answer, right, that we just need more First Amendment, right? So we just need to do more of it, and that's somehow going to get us to a better, more democratic, more open society. And I would say that the answer to that is no, because it isn't just that the First Amendment has been largely irrelevant to many of the most important democratic struggles in the United States. And it's not just that it has, in some ways, failed in really, really important respects as well. It's also that in some cases, many cases, the First Amendment's actually been hostile to pro-democratic speech. And that's what I'm trying to lay out in the book, because of course that's a counterintuitive idea for a lot of people, not for everyone. And the way that I spell this out in the book is really first through the question of history. I start in 1892. The introduction starts in 1892. Many of you are probably familiar with the name Ida B. Wells. So Ida Wells is running a newspaper. She's one of the few women who is heading up her own newspaper, and it's called the Memphis Free Speech. And it's a radical newspaper. It is an abolitionist newspaper. It is, not an abolitionist newspaper so much as it is a civil rights newspaper saying there are injustices going on that have not gone away simply because slavery has technically gone away. So, quite famously, Ida Wells writes an editorial where she says, the spate of lynchings that have been happening, of targeting Black men, they are justified on these grounds that, well, these men are committing these horrific atrocities, sexual atrocities with white women. And what Ida Wells says in this op-ed is she says, we're looking at all these, she was a reporter, she was a journalist, she went and she looked to see what was actually happening in these cases. And she says, what I have discovered is that almost all of these allegations of sexual assault are false. And not only are they false, many times they are being believed in or they're being put out there to hide the fact that in fact white women are voluntarily entering intimate relationships with black men, and that is the reason why black men are being lynched. They are now competing with white men, not just economically, but also in much more intimate ways. She says this in her editorial. She leaves town because she has many other activities that she engages in, so she's out of town. She's not in Memphis when this happens, but a mob is so fired up by this editorial, by the things that she says, that they come together and they don't know that it's her exactly. They assume that a man had to have written it, so they actually go after someone else first and beat him up and say, you can't write these things. And he says, well, actually, it's Ida Wells who wrote these things. And they say, we're going to lynch her if we can find her. And they ransack these offices of the newspaper and they burn it to the ground. And so my book begins in this moment of burning free speech to the ground, quite in this literal sense, right? To show that what there do we think of as a First Amendment story, right? It's 1892. Even if we had thought that the First Amendment protects Ida B. Wells's right to have this newspaper, what protects you from the mob? What protects you from someone who is going to say, I find what you are saying so unsettling and so upsetting that I'm going to respond with violence and I'm going to destroy what you've done here. And I take that moment and I say, this is not like a moment in history that is unusual, right? One of these blips. It is actually a continuation. So I go backwards in time and then I go forwards in time. Backwards in time to saying you've got the First Amendment ratified, right, in 1791. And then just a few years later, Congress does exactly what it says it wasn't going to do, right? Congress shall make no law that abridges freedom of speech, 1798 Alien Sedition Acts, right? Almost immediately, except for that kind of speech, right? And then you have this movement in the 1820s and 30s, the abolitionist movement that really takes off, the first really sort of radical democratic project that takes off. And it's this wonderful convergence of people who are protesting against slavery and also the mistreatment of women generally, right? And they have built a wonderful structure in which to have these ideas discussed. They build this thing called Pennsylvania Hall, and they build it in Philadelphia, and it is meant to be a temple of free speech. That's what it was referred to. And the kinds of speakers who were going to inaugurate this building included people like Angelina Grimke Weld, who was a famous abolitionist and also suffragist, William Lord Garrison, many others, right? So everyone who was at the cutting edge of radical democracy was there. And there were all these huge meetings where people were mingling together, Black people, white people, women and men, and that was very controversial. So controversial that as word of these events were spreading around town, angry mobs were showing up at the doors and they were saying, oh, I see who's going in. I see that there are Black men sitting with white women. And newspaper editorials were written about this and flyers were put up all around the city saying, if you care about your country, if you care about the Constitution, you will show them with force if necessary that they can't do this here. They continue to do it. They continue to have these speeches. Angelina Grimke Weld gives this amazing speech where she's trying to talk about the evils of slavery. Angry mob is throwing things at the sides of the windows. There are rocks that are being pelted, and she just keeps talking. And she says, let them try to bring their chaos here, because what does it show us except that we are right? And she says, what am I, and Angelina Grimke speaking from her perspective as a relatively privileged white woman to say, whatever it is that we could suffer, even if they break our bones, she says, it'll be nothing compared to what the average person suffers under slavery. So this is why we're here. So all of this goes on. It goes to a moment where the managers of the hall are so worried about the violence that's going to break out that they beg the mayor to send protection, beg the mayor to say, control the mobs that are trying to keep us from speaking. And the mayor says, I don't feel like doing that. What the mayor does say that he'll do is, I will go and I will tell them to go home, right? So he shows up in front of the hall and he says, you should all go home. And they disperse for a little bit and then he leaves. 30 minutes later, they come back. And when they come back, they've got crowbars and they've got improvised weapons and they storm the hall. And at this point, the speakers have fled, or they have left, and they storm the hall and they burn it to the ground. 1838, right, one of the first times when you have a convergent democratic movement saying, let's make the lie right now of our Constitution into reality, this is the response that you get. And they go forwards in time, right? So we were talking about what happens when people write about lynching, what happens when they talk about resisting the draft, right? What happens when you say you are all better served than you have better futures in front of you than to become cannon fodder, right? All of those speeches, all of those movements, right? Every time there is this radical action of speech, the government not only doesn't protect, but in some ways invites people to meet that with violence and force. So is that all ancient history? Are we better now, right? We get to 1969, and that is the kind of high water mark, according to many First Amendment scholars, when we start to get it right. 1969 is the Brandenburg case. Brandenburg case, some of you probably know, it's a KKK leader. And he calls up a local reporter and says, I want you to film my rally that I'm going to be doing on my property. And the reporter comes with a videographer, and they record this. And it is a Klan. They're all in these masks, and they have a burning cross, and they're moving around the cross, and they have Bibles, and they're chanting, and they're saying things like, we need to make sure that we eliminate Black people, Jews. Right? And that gets broadcast all over multiple stations. And Brandenburg is charged under a criminal syndicalism statute. And at that point, the court is reminded, of course, in 1969 of what it had done in the 1927 case of Anita Whitney, where she was charged under something similar in California when she had advocated against lynching and for women's rights, workers' rights. And they had found her conviction, her guilty conviction, they had upheld it, right? Even though there was some unease about upholding it, they had upheld it. They said, well, look, you can't say and do things that might encourage people to violence or to overthrow the government. In Brandenburg, they changed their mind. And they say, actually, we're wrong about that.
Hey, how are you?
Now we're going to have a really strict standard. We're going to have a standard that says that you are able to encourage a lot of violence.
There's still a lot of time.
Should I keep going or should I pause? Okay. That we're going to have a much higher standard for when we're going to be able to punish somebody for their speech. And you can look at that and you can say, well, that's evolution, right? That is us becoming more sophisticated when it comes to the First Amendment. You could also look at it as saying, well, when it was a woman who was saying, I believe in socialism, I believe in women's rights, I believe that Black men shouldn't be lynched, I believe that we need to all be part of one humanity, that the court was not willing at that stage to say that is supportable speech and we're going to protect that. But once it was a KKK member, they were somehow a little bit less concerned about the impact. And maybe that's a cynical view. But if we look over and over again at cases throughout history, I don't think it is. I think it is just the way that, in fact, the First Amendment has tended to work. So to tell you a little bit specifically about how the book goes through this here, and I'm happy to talk more about the details. In the book, I take on the theme of burning, and I talk about burning crosses in the first chapter, where I talk about racism in particular and how racist speech has gotten sort of overprotected by the First Amendment, how most of the famous cases we can think of involve either the KKK or neo-Nazis. And then there's a section on burning women and how often it is the case that not only are women targeted by people who will use the First Amendment to defend what it is that they are going to say or do, including things like stalking, sexual exploitation, is being presented as First Amendment protected activity. And we can talk a little bit specifically about the case called Counterman versus Colorado, which just came out a couple of years ago, where the Supreme Court basically said delusional stalking is protected free speech. On the one hand, at the same time, if a woman who has decided that she is going to write a letter, an op-ed, in the Washington Post to talk about and to bring attention to the problem of domestic violence and what it means to be someone who speaks out against domestic violence and to be sued for millions of dollars because of that. I'm talking about the Amber Heard case. She wrote an op-ed that people didn't like. Johnny Depp in particular didn't like it. Sues her, and what happens? First Amendment doesn't come in to save Amber Heard. Or does she become sort of a famous figure that is represented by the ACLU? No, she just loses. And at some point, she was thinking about appealing, and then she said, I can't, because this has cost me too much, right? She, as I'm sure everybody in this room knows, the campaign against her was absolute, right? She couldn't continue that cost. So where was the First Amendment there? When we think about the way that it is played out, not only in the racial context, but also in the gender context, that's the subject of the burning women section. The burning book section, which is the next one, and the burning down the public square sections are taking slightly different approaches to say, here's the other way in which the First Amendment has not only not been particularly protective of freedom of speech, but actually has been used in a way that is hostile to freedom of speech. Book bans, on the one hand, we would have thought fairly straightforwardly, most people would have thought at a certain point that that's always censorship, right? When the government says you can't have certain books, that would be censorship, right? But the way that we got to the burning books was not just one day people woke up and said, let's burn some books. No, there was a long campaign before that. And the campaign before that said, well, there are all these ideas that just seem really hostile, right? These ideas that seem to be making people feel bad, making them feel bad about the fact that they are white, making them feel bad about the fact that they are men. And there are a lot of these people who are snowflakes, and there are a lot of people who are being woke and they are embracing this thing called DEI, CRT. All of those things happen first so that you delegitimize some of the conversations that are happening on campuses. And so the book bans become an answer to that. The book bans don't come out of nowhere. The book bans are, well, we've got to get that stuff out of our schools, because next thing, merely what we should admire in a regime and think is essential to democracy. And that is the kind of speech that takes aim at power and criticizes it. Third characteristic is courage. Courage because if that part is true, you have taken aim at power and you are criticizing it, you might get hurt. That's important, and I think the way to really articulate the difference between what I would call fearless speech on the one hand, the Ida Wells of the world, the Anita Whitneys of the world, and distinguish it from the Brandenburgs of the world, is to say that's the difference between fearless speech and reckless speech. Recklessness, as I'm sure, again, all of you know, recklessness is a really useful legal concept that says it doesn't mean that you're trying to do harm necessarily. It means that you don't care if harm happens. You care more about the benefit to you than the kind of cost that it might impose on someone else. The best way to describe someone like Clarence Brandenburg is he really wanted to talk about his racial vision for America. He wants to share that vision. He knows full well that having that kind of propaganda, that dehumanizing propaganda about vulnerable groups will lead to violence, and it did. And he doesn't care, right? So whether or not it's the express purpose or you simply don't care, that's reckless speech. Same thing with the Nazis in Skokie, right? They want to talk about their vision of white supremacy. They do not care, and perhaps it is in fact their point, to cause the Holocaust survivor community in Skokie pain and fear. Reckless, as opposed to being fearless, as opposed to saying that risk that I'm creating with my speech. The fearless speaker says that risk is only fair, only just, only important if it's my risk, if I am the one who's risking something, not that I am causing someone else to be endangered. And that's probably the most fundamental characteristic that is key between fearless and reckless speech. So my favorite part of the book is the part where I talk about my 7 chosen profiles of people who really illuminate this concept. And I could have chosen 15, I could have chosen 30. There's some examples all throughout the book, but in this one section of the book, I talk about the ones that I give a little bit of background for and give you some idea of what it looks like to really enact those sort of principles. And that is the part that I find personally encouraging about the book, because this is the part that says, even when the law has failed, even when people have failed in terms of the legal defenses they might have, the legal definitions they might have, people still, for whatever reason, have chosen to risk themselves, to risk their own lives, even in some cases, to try to work towards a vision of democracy that is actually a real democracy, as opposed to simply pretending to be a democracy that already exists. So if there's anything else I want to say about the book before I hear questions or questions or discussion about some of these points, it's to say that really is where I think we can land as a community that might care about freedom of speech. To not let ourselves be constrained by a legalistic definition of freedom of speech, because that is what the First Amendment is. We may tell ourselves that if we're holding on to this concept of the First Amendment, that's what we mean by being brave, by being radical, by being revolutionary, but in so many ways, clinging to concepts that come from the First Amendment are the ways that we mostly blinker ourselves to the reality that's going on around us all the time, where people are not free all the time. Separating ourselves from that mythology, separating ourselves from that terminology lets us think, well, what about all the important conversations we can have, that we do have? Sometimes they happen in our homes, sometimes they happen in our classrooms, sometimes they do occasionally happen on social media. But all the ways in which we use language and we use our powers of persuasion or of expression to do good, or even just to see something in a way that we didn't see it before. It doesn't have anything to do with the First Amendment in lots of ways. That means that when we're trying to figure out how to have a good free speech community, we have to think about how we get to that point. Forget about the law for a moment and think, how is it that we actually try to share in common ideas together, ideas that help us see things in a way that we didn't see them before, and to care about things that we didn't care about before, and to include more people than we could include before. So that, I think I will stop and see if there are questions. don't know anybody's name, so I will just gesture generally in your direction.
Thanks so much for coming and giving this talk. This is really interesting. I just wanted some help kind of piecing the critique together with the concept of fearless speech. So it seemed like the critique was broadly a critique about the First Amendment, and we can say that's maybe like censor focused, like what the censor can and can't do. But then the concept of fearless speech is like what a speaker should do. So I'm not sure how these kind of go hand in hand, because one way of putting it is that maybe the best way to promote fearless speech would be to maximize censorship and oppression, because that creates the conditions under which fearless speech is likely to emerge. So yeah, I just wanted some help with the concept.
No, that's very well taken. I do say this in the book where I say the fact that there are people who are willing to risk their lives and know that the First Amendment or any law is not coming to save them is not something that we should feel good about, right? We can praise their examples, but we shouldn't feel good about a society in which that is necessary. So in the section of the book where I talk about how it is that we can bring about a fearless speech culture, I say we have to work to make the conditions such that people don't have to be fearless in order to speak. So yes, thank you for allowing me to clarify that.
Hi, thanks for a very engaging discussion. I want to push back a little bit on your concept of reckless speech. You described the individual issue in Brandenburg as articulating his racial vision for the country in a way that could lead to violence, and probably that he knew would lead to violence. I would say that we have kind of a proud tradition in this country of people articulating racial visions for the country that they probably also knew would lead to violence. I mean, many of our most venerated civil rights leaders did exactly that. And so, I'm not really sure that it's a generally applicable principle outside of, maybe our priors. And the second thing is, yes, it's true that the Supreme Court has very often chosen really disfavored people to make up these cases, like Brandenburg or Village of Skokie, et cetera, et cetera. And it's not because, we love Nazis. It's because we are trying, I say we, the Supreme Court is trying to make the point that the free speech tent is supposed to be aspirationally as broad as possible while we maintain an ordered society. And isn't that a point worth holding on to? Not the fact that Brandenburg or the Nazis in Indiana or wherever it was got to have their parade.
So on the first point of what you said about lots of racial visions could include violence. This is something I think that benefits from really getting into the details, right? About what it was that someone like Brandenburg was saying. He wasn't saying, I just really like white people, right? He wasn't saying that. He was saying, I think everyone who's not white should get out of this country. They don't deserve to be here. They are insects. They are lower than us. That is not the message of the civil rights movement, at least as far as I understand it, right? When you have civil rights advocates who are saying Black people should be included as equal human beings, that's actually quite the opposite, right? It's not flipped. And I think this is a part of the problem with the First Amendment constraints, is that we tend to think of them as being basically the same, two sides of the same coin, but they're not. It's not as though we're saying, oh, I love white people on the one side and I love Black people on the other. That's actually never what's at issue. The messages are fundamentally different. When Anita Whitney says, and is convicted and her conviction is upheld, when she says that the greatest shame of America right now is the lynching of Black men, she's not actually doing the opposite of Brandenburg. She's just saying a completely different thing. Whereas he is saying, I want violence to befall, Brandenburg is saying, I want violence to befall everyone who is not white. So I think it matters very much when we look at what the message is. And then to the part about disfavored, they're not disfavored is the thing. So this is part of, I think, why the line on the First Amendment about we protect disfavored speakers. Do we though, right? Because disfavored speakers, when we think about how power has worked, disfavored speakers are the people who were saying slavery should be abolished, women should have full equal rights, it's bad that lynching happened. All of those people are the disfavored ones, and the First Amendment has not stuck up for them. So when we tell ourselves, oh, it's not because we love Nazis, well, then why is it always the case that it's basically Nazis? Is one version of the question. And I know there are exceptions, right? There are important First Amendment cases that did, I think, have a much more sophisticated view of saying we want a general principle in which people can say rude things, arrogant things, just offensive things, not because we love them, but because we need space. We need space for those things so that we don't crack down on the other things. That, I think, makes a lot of sense. In the book, I say that there are lots of principles, especially the one that I keep coming back to, which is the government shouldn't be allowed to punish you simply because it doesn't like what you're saying. That is a very good principle. But that really isn't the principle that explains Skokie, and it doesn't really explain Brandenburg. It goes a lot farther than that. So what I would push back against your question is to say we tell ourselves that they are disfavored, but the we is doing a lot of work here when we say it's speech that we don't like. Is it? Today, in this moment, in our historical context, do we think that Nazis are disfavored? Are they the ones who are being targeted by programs, edicts, executive orders, legislation? Are they the ones who are being disfavored? And I would suggest that the answer is no. We are much friendlier to, however we want to call it, maybe we don't call it Nazis, but people who are saying whiteness needs to be at the top, maleness needs to be at the top, and everything that suggests differently needs to be ruthlessly suppressed. So I would not call that disfavored, and I wouldn't say that's just a product of this historical moment, but basically a fairly continuous project throughout US history.
Yeah, thanks for being here. I'm really sympathetic to what I took sort of the second half of your talk to be about the role of fearless speakers. I take that totally on board. I guess I have more questions about the first half, which seemed to say that the First Amendment is hostile or inimical to more capacious understanding of free speech, or maybe even for the speakers themselves. My question is, like the examples you give were about Amber Heard, that choice. Is your objection to the First Amendment as such, or is it to the ACLU for not coming to Amber Heard's defense, or to the legislatures in Florida and Texas for writing those laws, or is it to the court the way that they've been enforcing the First Amendment, or is it a sort of implementation problem, or is it something about the logic of the First Amendment doctrinally or as written that you think is problematic?
All of the above. In other words, what I'm saying is that if what we tell ourselves, and this would be wonderful if, huge if true, if the First Amendment actually prevented the First Amendment is that it deters and restrains government, it hasn't been, not for a long time, right? Didn't even constrain Congress that had written and ratified, right? We're not going to make any laws that abridge the freedom of speech, except in 1798 when we immediately started doing exactly that, right? So that's a failure. Do we call it a failure of implementation or of litigation? I don't know, but what we know is that the First Amendment, whatever we do mean by that, isn't stopping any of those things. Now, does that then mean we can have a broader vision of the First Amendment that does better? Yes, and I think we often do. And sometimes the ACLU has it. I don't mean to suggest that they're always wrong about the way that they would carry this forward. And I think the net choice case actually came out correctly, because part of what Justice Kagan says is, whatever bias there might be in these private companies and how they're doing their algorithms and what have you, all we really do know is that the worst thing than whatever the private companies are doing to change people's, to alter people's feeds or not give them what they think they should see, is for the government to step in and do it. So I think that was actually the right decision. But you see a decision like Counterman, where Justice Kagan again says, well, I know that Colorado and many states think that it would be important for women, life-saving in fact, for women to be able to get restraining orders and convictions against their delusional stalkers, but I am more concerned that someone will look at this law and be chilled from saying something important politically, and therefore he can't be convicted on these grounds. And the musician, the female musician who was the target of this particular stalker, who basically changed everything about her life, shut her own music down, walked away from her art and her expression, did not factor into the court's analysis at all. So is that a failure of the Supreme Court? Is it the failure of the doctrine? Is it the failure of the way the case was litigated? Maybe all of those things. But it shows us that the First Amendment isn't going to stand up for someone like the musician who was victimized by the stalker in that case. So I think it's a lot of those things in any given situation, but that if we are going to have a better First Amendment, we need to be honest about that. We can't keep telling ourselves, well, every bad case or every time there wasn't something that worked out the way it should, it was just that it wasn't First Amendment-y enough, right? Maybe there's something fundamentally wrong about the way we applied it or the way that it was enacted or the way that it was litigated, but we have to confront that as opposed to just sort of doing the kind of version of the no true Scotsman that says, well, that wasn't really the First Amendment, or that wasn't the First Amendment as well applied as it could have been. We have to say, this is a failure of the First Amendment, let's do better.
Following a bit of this question, I mean, from what I gather from your talk, and thank you so much for coming here and talking about this, is that the way that free speech is applied in this country is not unlimited and unconditional, but rather qualified, conditional, and instrumental. And my question is whether this instrumentality of the application of free speech requires the fact that you need to be in a position of power. You are defending a sort of hegemonic system of power that kind of allows you to be instrumental, allows you to apply free speech not in a, let's say, in the same way across both aisle or across different dimensions, but rather in a way that serves the power, quote unquote. And if that's the case, shall we find the reason for the free speech be applied instrumental in the law or rather in politics, and how politics kind of like interprets free speech and the instrumentality of free speech?
I think probably my simplistic answer is that if we ever had a distinction between law and politics in this country, it is gone now. So I don't know how to answer law or politics because I think it's always politics now. And that's part of what I'm worried about, right? And I think that when we think about, just to take, maybe this will be meaningful for some of you in the room, we think about the concept of privacy, right? And we think about the fact that we have a constitutional dimension to that. We think about Fourth Amendment law, right? But for most people who care about privacy in any kind of meaningful sense, we would never try to say, well, the Fourth Amendment tells us what privacy means. And when you uphold the Fourth Amendment, you've upheld privacy. Anybody who studied the Fourth Amendment would say that's absolutely not true, right? We wouldn't understand that that is such a limited way of looking at privacy or this value that we care about. And yet with the First Amendment, it's almost as though we say, yeah, but the First Amendment is different. It's the first among, equals, right? And that the part of our brain that would be more skeptical about the political ramifications or the power analysis turns off and we say, but when it comes to the First Amendment, that's the apolitical one. That's the one that is not subject to power to politics. And my answer to that is that has never been true. And it's definitely not true now.
So I found the book really provocative and really interesting, and I just wanted to ask you about one of the examples in it. So you bring up pretty early on this sort of discussion of birth of a nation, and one of the things that you bring up in talking about birth of a nation is that having sort of a First Amendment defense doesn't work from the grounds of, well, it allowed people to oppose it and to criticize it. And so this suggestion seems to be that this film should be outside of First Amendment protection. And I just wonder, concretely, what does that look like? You've got a racist film here, what does the state do about that? What are the consequences for that? And particularly in the present moment, if we think about giving sort of the state power to regulate speech that we find is harmful, where do we trust that power to lie?
Yeah, and you'll notice if you have read the book, and thank you for reading the book, that I don't give an answer as to whether I think Birth of the Nation should be censored or not. And the reason why I don't is because I don't think that is an easy question to answer. I think a lot of the assumptions about the way that I've written that chapter, people would come away thinking, well, you want the NAACP's position on that, which is basically ban it everywhere. And I don't know that I would. Partly because I do find, as much as I don't find certain things compelling about the way the First Amendment analysis in the civil libertarian context goes in that case, one thing I find compelling is it's not going to help. It's going to be counterproductive in one very specific sense. You try to get rid of it, you automatically have a number of people saying, well, that proves that there's something to it, right? So you'll get more, it's going to be a bit of a Streisand effect type of idea. So on a practical level, strategic level, I don't know that it makes sense to try to ban movies, words, concepts, right? Which is why I'm pretty resistant to any of those. But the idea in the book, what I talk about is the ACLU sort of rebuking the NAACP and say, if only you understood, how the First Amendment really works. Because today it's going to be Birth of the Nation. Tomorrow it's going to be a film that you, civil rights leaders, like. And what I find so aggravating about that, other than the fact that it's incredibly patronizing, was the fact that, of course, that censorship was already happening. Black films were being censored. That was already the case. Notoriously, the censorship boards were not letting people watch the Jim Jeffries fight because a black man beat a white man, and they didn't want people to see that. So the idea, and this is what I call, in an insulting way, I call the bad precedent theory, is almost always wrong, because it gaslights you. First of all, it tells you that when you say something's setting a bad precedent, you have erased the fact that it's not setting up, it already happened, right? It's already happening. And it suggests to you that if you just hold off today, if you just don't ban Birth of the Nation Day, then no bad things will come to you. That is just not true. And there's a larger political question here about, well, what do you do when someone is breaking all the rules against you? Do you keep looking at the rules and saying, well, I'm not going to break mine? Well, you could do that, right? But then where will you ever go? So I guess my answer is I don't generally think that I want the government to say that film, that word, that concept. So exactly what's happening now, the idea that you could have a list of words and say, just take them all out. No matter what those words were, whether I like those words or I don't like those words, I don't think we should go and say that piece of art, that kind of, no, it's not going to help. But if we go back to the Counterman case and we ask ourselves, what about those difficult measures where we say, well, something that causes concrete harm, right, that we would normally have thought of as a genuine criminal injury, were it not for the fact that someone is now making a First Amendment argument, well, that seems like it ought to be taken more seriously. And most of us do when we think about things like child pornography. There are a few people who want to argue for First Amendment protections for child pornography, but most people say, you know what, it could be expressive. There might be a lot of, there's obviously some expression involved in that, but it's perfectly okay for the government to say, not that though. So when we ask the question, well, who gets to decide? As a practical matter, we all know who gets to decide, and it's not me, and it's not any of us. It's going to be legislators, and then it's going to be courts, and then it's going to be, to some extent, the ACLU and whether or not it wants to take up your case. But someone is making the decisions all the time. And part of the question is, are we going to hold them accountable for the kinds of decisions they've made? Are we going to let the First Amendment mythology tell us that, oh yeah, we never want people to tell you what you can and cannot look at? Sometimes we do, actually, right? We have those historical categories and a bunch of other categories that we'd say, yeah, actually, we're perfectly comfortable saying you can't just do whatever you want. So let's think about why that is in that category. We think that child pornography is not First Amendment protected. Why is that the case? If the answer is something, as I think it should be, is that it is more harmful than it is beneficial, let's be honest about how that's a pretty good way of trying to judge these things and try to apply that from case to case. It's going to be messy, but that's what the law is, and that's what the law does.
I was curious, you spoke about kind of working towards a better First Amendment. You also mentioned, from a comparative law perspective, that you weren't sure the First Amendment was necessary, neither sufficient nor necessary for a better way of dealing with expression. Are there other countries you think are worth emulating, or what would be a better paradigm to work under for better ways of thinking about expression?
Yeah, it's a bit of a dangerous question for me because I'm not an expert in any other country's laws. But when I look at those rankings and I look at why it is, for instance, that Scandinavian countries are at the top of all of those rankings usually, right? Both in terms of freedom of expression generally, as well as press freedoms. And I think they have figured something out that we haven't, right? That you have better mechanisms to keep out dangerous misinformation. You don't mislead your public. People are not confused about what actual science is. All of those things are better measures, and people are able to express themselves more freely than I would want to borrow from those kinds of examples. So most of what I've looked at so far have been Scandinavian countries, although the United Kingdom actually does score better than we do, I think, in both press freedom and freedom of expression. So I think that's worth looking at too, because a lot of the kind of chauvinistic talk that we do in America says, oh, well, we don't want it to be like the UK where you can get arrested just for blaspheming or whatever the case is. I point people to the fact that, during the first go around with Trump, the woman from Code Pink who laughed during Jeff Sessions' confirmation hearing because she found it so ludicrous that he would say that he cares about racial justice, she was arrested and she was convicted, right? So the idea that we don't do those kinds of things and don't have those successes, I really would say, yes, it sounds like at least some of the Scandinavian countries have a better and more sophisticated view of how to handle the complexities of expression and the harms of expression.
Thanks so much for this. Just to take things up maybe like a meta level, I wanted to ask you about sort of your vision for the book, its intended audience, and how folks have been receiving it as you've been talking about it.
So the last one, it's been really mixed. There are some audiences that are intrigued by some of the ideas. There's been a lot of, and maybe this is perfectly expected, right? And it's not as though I was completely surprised by the idea that people would find this very upsetting. With my first book, which was titled The Cult of the Constitution, same sort of like blowback, right? Of the idea that you are taking something that a lot of Americans consider to be as I said, in the cult of the Constitution, almost like a religious value, right? And they get very upset about it. So there have been, I am, whatever list it is that FIRE has of people they really hate, I'm on it, right? So Greg Lukianoff really annoyed with me. So, okay, that's fine. But I also find it really telling, right? Because if you have people who claim that they care about freedom of speech, and certainly someone who works for FIRE, who FIRE has kind of been on this agenda of saying, oh, cancellation is the worst possible thing, and all ideas have to be, for someone like Greg Lukianoff to then write an entire piece that says that professor in her book is destroying America, right? Okay, well, that's an interesting position to take, right? Especially at a time like this, especially when actual government censorship is going on all around us. But so I would hope that actually, though, in those conversations would lead to something, maybe a moment of, well, perhaps there's something here that's been revealed that is worth exploring, even if he doesn't want to do it publicly. That's okay. It can be an internal change. But other than that, I really do want students, I want professors, I want anyone who has thought to themselves, whatever it is about the First Amendment that I've been taught to believe, if I've ever had a moment of discomfort with it where I thought maybe I'm missing something or this doesn't seem to be right, that it says to them, actually, you may be onto something, but that doesn't mean we don't care about freedom of speech. It means that we might have been constrained by the First Amendment, and that's something we can stop doing. We can stop having these really limited conversations. I'd like to think that legislators would read it and think, well, we should think carefully about how that, yes, if we think that we're all on board with the idea that, for instance, child pornography should be illegal, well, then can't we use those same arguments or some of the same analysis to say so-called revenge porn should be illegal, right? That's a way of trying to be more honest about the costs of the process of legislating these kinds of questions. And yes, that I'd want students to be able, who are interested in the First Amendment, to think, or about free speech, to think, freedom of speech is so much bigger than whatever you might get out of a First Amendment casebook. And I teach the First Amendment. I like those casebooks. They're great. But they all kind of replicate the same idea that this is the universe of freedom of speech, and the ways that we could think about freedom of speech are all kind of contained within this doctrine. I'd like people to believe that that's not true. Thank you for that question. Hey.
Well, wonderful to see you.
Nice to see you.
Especially since you wrote a letter to get me here. The question I have relates to the characteristic of candor. And this came up with the question that was brought up about Birth of the Nation. There was a Dunning School at the time, and this is referring to academics. And I'm asking the question as, what is the role of academics, particularly in most of the social sciences, and today the quote-unquote respectable social sciences tend to be those that appear to be quantitative and econometrics. And when we hear economists give their presentations, you see them detach themselves from what they obviously know that their research is showing, and trying to separate themselves from not identifying with a norm. And and I'm asking that because I remember Black Reconstruction being a book that got censored, and the Dunning School, which had this myth of Reconstruction, was reinforcing films like Birth of a Nation. And it was the American Historical Review that just until 2022 finally did some reconciliation, had a Professor Hinton write on a review on Black Reconstruction and admitted that they censored Du Bois's Black Reconstruction. So what's the role of academics in maintaining candor and identifying with their position as opposed to saying, I'm neutrally detached?
Oh, that is such a good question. This is why I wrote you that letter. I think, one answer to this is to say, I'm thinking about this particularly, you were using the examples of maybe historians or economists, and I'm thinking about law professors. I'm thinking about the way that we often tell students, right, that you have to be objective, right? The law is objective. You're going to feel all these emotions, but you're going to have to be objective. And that, of course, again, as an aspiration, I think is a good thing. Like, we should all be looking for, I don't know if objectivity is the right term. What I really would want us to be thinking is to all learn how to be anti-exceptionalist. That is, just because I feel a certain way is not a sufficient reason for a case to come out a certain way or for a law to be interpreted this way. That, I think, is the important lesson. But of course, emotions are, the thing that we miss there is that we're suggesting sometimes, I think as the law professoriate, we sometimes suggest that objectivity is achievable and it's what we're doing right now, right? And I think we all have to be honest about how that's never true, right? It's never going to be the case that you're speaking from the point of objectivity. You are speaking maybe from the perspective of trying to get to objectivity, which is a noble thing, right? We have to start by saying that it is not a given, it is always something you have to demonstrate. So I think I'd want to see more of that, right, from the legal academy. And yes, some more of the, let's grapple with the consequences. When you think about so much of First Amendment scholarship, you think about how, I think it was Mario Matsuda who had said, the way that civil libertarians will tell you about the cost of hate speech and what have you, and say that we just have to all tolerate it. And she says, it's not we. You know, the people who are going to have to take on the burden of hate speech are the people, it's a tax on those least able to pay. Right? And there's something really meaningful about that, to consider your own position in this and how easy is it for us to say, any of us to say, well, you see why we had to defend the neo-Nazis in Skokie, but we're not really thinking about what that means to have actually been potentially one of those people who had just escaped the Holocaust, right? And is watching somebody march down the street in a Nazi uniform, in a swastika, right? Are we really thinking about the cost to them? Because it's not the same thing as a cost to an academic or to someone who is completely removed from that situation. So I think part of what I would want, I don't say it so much in the book, is I wish we would be more, maybe candor is not maybe not the right word, but yes, we should be thinking more about what the actual costs are of expression. And if we're going to endorse these abstract concepts, to make sure that we have thought about the actual impact on people who are not necessarily going to be immunized or surrounded by support, right? Because that is what irritates me, and irritates not even the strong, I need a stronger word for this. So this kind of cavalier sort of attitude about how if you were just sophisticated enough as a civil libertarian, you'd understand that however painful that is. Like, we know hate speech is bad, but you know what's worse in government? You know, as if the government isn't always involved in all these decisions all the time, right? And it is this kind of patronizing sense of I'm objective, you're emotional kind of idea that I do think we have to really rethink.
On the idea of objectivity and emotions, I'm curious about the concept of power and like how stable it is and how to identify it and what to make of the reality that so many people who I think and it sounds like you would view as very powerful, in some ways are getting their power from identifying as disempowered, and the very often real emotional experience of, I think, many people feeling like, you know, the government is against them and the broader society is against them, especially men, and as gender changes in our society, the fact that some power dynamics actually might be moving, and just what to make of the concept of power.
Yeah, I use a term in my first book, and I think I replicated it in the second, and for what I think you're describing, I called it victim claiming. So it's not just about denigrating a victim, but saying, actually, I'm going to take up the mantle of victim, and not only because I, the person who wants to assume that mantle, want all the sympathy and the kind of deference that gets, I also want to take it away from that other person. Because if I'm standing there in that position, then that person isn't, right? So if conservatives are saying, powerful conservatives are saying, well, you know, we are being suppressed, then not only are we supposed to be responsive to that claim of suppression, but also don't look at all the people actually being suppressed, right? It's such a powerful move. It's what's so dangerous, I think, or what I've suggested is so dangerous about the whole, you know, the campus crisis, you know, kind of narrative that we've been taught for at least 10 years about these super sensitive students, and that the worst possible thing is that some professor somewhere can't say, I don't know, a racial slur out loud without getting criticized for it, right? The idea that is, you know, there may be a problem there, right? But the idea that that's the person we most need to worry about, right? Not only puts that person in a position of, you know, that victim authority, but also says that student somehow, or that power there is somehow bigger than it is. Because let's face it, if we're talking about universities, we're talking about any of these contexts of campuses, it's not the students who have the power, right? At least not in a broad sense. They might in one, you know, in kind of certain contexts and interactions, but the power structures are not the students, right? So I think it's really important to be able to highlight that and to talk about that as a dynamic. And it's really troubling, right? Because, you know, as I try to go through the fearless speech paradigm and try to say, well, this is how we can distinguish between these things, one of the things I always worry about is, well, don't so many people who think, for instance, the insurrectionists on January 6th, right? They say, well, we're fighting its power, right? And we're all here openly and we're taking risks because we could get in trouble for this. Aren't we the most fearless speakers? That's the kind of question I have to contend with, right? And I think my answer to this would be, when we say you are fighting its power, it can't just be a self-reporting phenomenon. You can't just say, well, it's not enough for you to make the claim that you are a victim. There has to be some proof behind it, right? And once you start to unravel, well, what is the claim you are making? How is it that you are fighting its power, right? When you say that, you know, you're victims of some kind of partisan steel, and you've got, you know, Mike Pence who's saying you're not, though, right? So then what happens to the argument of saying that you are the ones who are being disempowered when you're calling for the head of the very party that you think has been wronged, right? But I don't want to oversimplify any of that, because the other psychologically profound part of this is people on some level really do, people with much power are also in some ways disempowered and vulnerable. And when you exploit that, when you tell them, yes, those feelings of being uncomfortable or uncool or whatever, I'm going to tell you that those are all so unjust for you. And you're right, all those people out there making you feel like you're less than. I'm going to make you not think about their economic status or about how they're way more vulnerable. I'm going to make you think about how you were uncomfortable that one day when it wasn't all about you. And that's such a powerful way to get people in, right? Because powerful people don't like to think of themselves as powerful. They want to be the center of attention for everything, including when people are suffering. So it is a hard thing to untangle because some aspect of it might actually be real and sincere, and there's a way to talk about it, but not at the expense of saying you get to occupy that position when, structurally speaking, you don't belong there.
Thank you very much. So I'm from the Netherlands, and
I'm a big fan.
About American free speech, and usually we hear it in a distinction: is there free speech is more absolute because there's no prohibition of hate speech. That's the distinction, how we're taught it in high school, so to speak. That's not fully true. But what I hear in your story is that a lot of times there's also private violence and there's no protection from the state. Does that mean that here there is no positive obligation for the state to protect the free speech of marginalized groups?
Right.
And you also say, well, government intervention isn't necessarily good, so should there be a positive obligation like that? Or will that be co-opted? Is there a institutional problem that favors white supremacy to the point that if you protect free speech more proactively, you exacerbate the problem?
That's a great question. And for the first part, as you said, and I think maybe that's what you were, I always bristle a little bit too about this idea that, you know, in the United States, we're absolute because we protect hate speech. You know, that is that's such a strange way of looking at things, right? Because of course, hate speech is not a settled upon term, right? You could say, for instance, that if a racial slur shouted in the middle of a public park, are we allowed to punish that? Maybe not. But if you're shouting it at work, we can actually punish that, right? So hate speech is in some ways not protected in the United States, and in some ways it is. And I think for a lot of people, if you think about what some of those forms of hate speech actually are, we'd all be in broad agreement they should be prohibited. If you're threatening somebody's life, that can be very hateful, but we mostly agree that that's the kind of thing in the United States, even with the First Amendment, that's not protected free speech. But to get to your point, one of the most complicated things about the United States legal structure, or most controversial aspects, is that there's basically no actual, I'm oversimplifying a bit, but because of, or as illuminated by the DeShaney versus Winnebago case, that the government doesn't have any obligation to actually help you, even when you need it, and even if they are the only people basically who could help you. So that is a pretty serious aspect of the US law that is not restricted to the First Amendment, but it's a big problem if we care about people, right? And so the idea that should we protect other people from private violence, it's a complicated, private censorship, right? It's a complicated question because if you think about New York Times versus Sullivan or any of these civil defamation suits, it's private party versus private party. And at some point the courts can intervene. So it's complicated. It's not just a private versus government. If we say that we're trying to protect your free speech through some kind of defamation action, you can on some level get some government intervention on your behalf or against you. Would we want more of it? This is the tricky thing, right? Because on some level, that is the version of events that Florida and Texas were giving for social media. They were saying, look, conservatives are being suppressed, so we're going to need some government intervention to support their free speech, right? And I don't buy that, right? Is that the same thing as what I mentioned a little bit in the book about some of the work that I do that some of you may know about, which is revenge porn legislation? Adding to the list of crimes that we have now to say that something that has not been criminalized before but should be is sexual exploitation of people's private information that happens to be nude or explicit imagery. We should consider that to be a crime. One reason for that is to say we want to protect people's privacy. The other argument I've made is to say it also is a way of protecting people's free speech. Victims of non-consensual exploitation in this way shrink. They stop talking. They won't go to events. They won't continue with their work. They won't take certain jobs. It costs them their speech. And I make the same claims about stalking. Stalking isn't just about terrorizing a person in this kind of obvious way. It's also you stop making art. You stop being able to speak freely. So I would make the argument that every time the government fails to criminalize those types of actions and fails to punish those who have been shown to have committed those actions, the government is actually failing to protect the free speech of its citizens. But of course, anytime you bring the criminal justice system to bear on anything, there's a danger that it's just going to become one more tool that more powerful classes use against less powerful classes. I think that's true about every law, and I'm still willing to say that I still believe that homicide laws should exist, even if they are going to be badly applied. We work on them and try to make them better, but I wouldn't want to give up on the idea. So I would say it's worth the risk some of the time.
Excuse me, you guys can stay, but the custodial has to come in and take care of the trash. The room's open.
And on that note.
I was hoping that the note that we would end on was, thank you for sharing your wonderful work with us and for this incredibly engaging discussion in which I've learned not only more about your work, but also how to have difficult conversations.
Thank you.
Thank you so much.
Thanks so much for the questions and for the opportunity.